Hi, and welcome to Hull & Hull TV. I'm Suzana Popovic-Montag, the managing partner of the firm of Hull & Hull, a firm that specializes exclusively in estate trust and capacity litigation. Here at Hull & Hull TV, we explore estate and planning issues as they may affect you. Today we're going to continue on with part 2 of our two-part series on will challenges, and I'm pleased to be joined once again by our co-founding partner, Ian Hull, and counsel to our firm, Jordan Atin. Thank you for joining me today, gentlemen. We did finish off a little bit abruptly on our first part when we were talking about the initial introduction to the idea of will challenges. And what I thought we might do is just discuss a little bit about the kinds of materials that actually get filed with the court when you're challenging a will.
Sure. Usually the person who is bringing forward the will challenge will file an affidavit of some sort, setting out who the parties are, who are the relevant parties that have to be served. And it's important to remember that you have to serve people that are in the will and people who would take if the will is struck down. And if you're challenging more than one will, basically everybody who would take under prior wills or as if there was no will on an intestacy. And so basically the court wants to know, do we have all the proper parties? And perhaps we're involving the government, the children's lawyer's office, or the public guardian and trustee, if there are certain people who are incapable or minors, et cetera. So that's important information that you've got to file with the court at an early stage.
That sounds pretty ominous, really. That could be a lot of people that actually get it drawn into a will challenge that perhaps really only financially affects a handful.
Yeah, I mean, you can have 40, 50 people appointed or named as respondents. So because everybody who has the right to be there, who has a say in, is this will valid or not valid? And so you've got to make sure that you've named, and these people who might take. That's sometimes people that we miss, and courts want to know that we've covered all of that.
And Ian, how do we know who's going to participate ultimately after you've named maybe 40 or 50 people?
Well, it's nice. I mean, the system the rules corral people in a little. We're expected to file an appearance if you're actively going to participate in the lawsuit. And many of these people that are on the fringe will typically sort of team up with a group or stay just out of the way. You have lots of options there. But the three components of what all the parties are going to see in terms of the evidence is of course, the medical records, the lawyer's notes and records, and typically the financial records if they're relevant. So these people, even in the fringe might have assistance for us. They might be able to say, look, I remember I took Aunt Betty to the doctor all the time, and while I was in 3 wills prior, I was around her at the time that is relevant. So this massive group can also be a good thing because they're actually resources in terms of feathering out all of the facts.
So although they're named as parties, per se, they could be very valuable witnesses. What about their concerns? And I hear this many times when people get served with materials and they're not necessarily the active participant, but they're very worried about the fact that they've been, served with a document quite formally and that lawyers are involved and the matter's going to court. How do people protect themselves in those situations if they can't necessarily participate because they can't afford a lawyer or they're not that affected by the ultimate result?
Well, they have 2 options. I mean, one is just don't do anything, and you can do that. The other is there's something called a submission of rights. And so you can say, look, I want to know when this ends. I don't want to participate. I don't want to be responsible for costs, but I want to know if there's a judgment one way or the other or a settlement. And there's a form, and it's a specific rule that deals with that. And so that gives the people the ability to at least know what happens.
So if we look a little bit to the law now, just in terms of grounds on which people can challenge a will, what are some of the grounds that people will typically raise a will challenge based upon?
Well, the core grounds are lack of testamentary capacity, so lack of understanding the nature and effect of the document at the time you signed it. And that's a cognition issue, and that's an ability to understand. Another core element of a will challenge is undue influence, so where someone has forced and coerced someone to sign the document. You have to have it properly executed. That's another element. So you get into different variations on the theme, but the basic core of any lawsuit surrounds, did the individual have the mental capacity to do what they were doing, or was that individual so vulnerable and was he or she pushed around into signing the document?
And as we sort of wrap up this second part of our series, Jordan, do you have any practical tips that you can leave us with?
Well, if somebody's concerned that their will is going to be challenged, they should go to a good lawyer who knows what they're doing as far as wills and takes good notes. I mean, good notes, as we all know from the lawyer, are so crucial. Assessments by doctors at the time the will is made are great. So you can be defensive and help bulletproof that will if that's a concern, and it'll be money well spent, because you'll spend much more than that if there's a fight.
Great advice. Thank you very much, Jordan, and thank you, Ian, and thank you for joining us at Hull & Hull TV.